The U.S. privacy environment is a complex tapestry woven from various federal and state laws, each designed to protect personal information in different contexts. Unlike some jurisdictions with a single, comprehensive data protection law, the United States approaches privacy through a sector-specific lens, creating a patchwork of regulations that can be challenging to navigate. This video explores the key aspects of understanding U.S. privacy laws, including their scope and application, methods for analyzing a specific law, determining jurisdiction, and the concept of preemption. Scope and application. U.S. privacy laws are characterized by their specificity and targeted application. They often focus on particular industries, types of data, or activities. For example, the Health Insurance Portability and Accountability Act, HIPAA, protects health information, while the Children's Online Privacy Protection Act, COPPA, safeguards children's online data. Understanding a law's scope involves identifying the entities it regulates, e.g., healthcare providers, financial institutions, educational institutions, the types of data protected, e.g., personal health information, financial data, student records, and the activities it covers, e.g., data collection, processing, sharing. Analyzing a law. When analyzing a privacy law, it's crucial to dissect its requirements, exceptions, and enforcement mechanisms. This involves a detailed review of the law's text, including definitions of key terms, obligations for data controllers and processors, rights granted to individuals, and the conditions under which data may be collected, used, and disclosed. For instance, understanding HIPAA requires familiarity with concepts like protected health information, PHI, covered entities, and business associates, as well as the privacy and security rules that outline specific compliance obligations. Determining jurisdiction. Jurisdiction plays a critical role in the U.S. privacy landscape. Many U.S. privacy laws have state-specific counterparts that may offer additional protections or requirements. For example, the California Consumer Privacy Act, CCPA, and the Virginia Consumer Data Protection Act, VCDPA, provide residents of those states with specific rights regarding their personal information. Determining jurisdiction involves examining both the location of the data subject and the location of the entity handling the data. It's also important to consider the extraterritorial reach of certain laws, which may apply to entities outside the jurisdiction if they process the data of residents within the jurisdiction. Preemption. Preemption is a legal doctrine that arises when a higher authority's laws supersede those of a lower authority. In the context of U.S. privacy laws, federal laws may preempt state laws if there is a conflict, rendering the state laws inapplicable. However, many federal privacy laws explicitly allow for more stringent state laws to coexist, creating a situation where businesses must comply with both federal and state regulations. Understanding preemption is crucial for assessing how different layers of privacy laws interact and which standards apply in a given situation. Conclusion: navigating the U.S. privacy environment requires a nuanced understanding of the scope and application of various laws, the ability to analyze specific regulations, knowledge of jurisdictional issues, and an awareness of how preemption can affect the applicability of laws. As the digital economy continues to evolve and new privacy challenges emerge, staying informed about these aspects of U.S. privacy law is essential for organizations seeking to comply with their legal obligations and protect the privacy of individuals.